Today we are covering, and I'm sure you know the topic since you're here, but it's Estate Planning 101 for everyone that's online. And today we have Brother Chris Morgan here to help us facilitate this and talk about it with us and help us understand and learn some new things. We are going to discuss wills, trusts, and estate planning. And he is not promoting himself. He wants to make sure everyone understands that we have asked him to come and help us learn these topics. It is not a promotion, and this event is for educational purposes only. And we do not endorse his practice as a stake, but we are very grateful that he is here and willing to share his insights and knowledge with us. So thank you very much for your time. He's going to mostly be taking questions, so hopefully you brought some questions with you, and I'll just turn the time over to you.
Okay, thanks. My voice is a little bit weak, so I apologize if I'm not very loud. So if you can't hear me because you're old, like crank up your hearing aids and then go home and watch the YouTube video. And you're like, hey, look, that's me. I'm on TV. I am a lawyer. About once or twice a week, I get a question that asks if I actually am a lawyer, because this is how I dress. And I usually say, honey, yes, you were there. I went to law school. But my practice is very specific. The only thing I've done for the last going on 12 years are wills, trusts, and estates, which if I'm in court, and I do have to go to court sometimes, that usually means that I've done something wrong. And I have done things wrong because that's kind of how this works. It's called a practice. I'm just learning. But the idea is if something messes up, that's when it's in court. The idea behind estate planning is trying not to cause the conflict. It's trying to avoid it before it happens. So a couple of things that I see where I kind of go, oof, is when I'm looking at the internet on my Facebook feed and I see, come to an estate planning seminar. It's free and we'll give you a stake. I know the lawyers that are running those, and I know how much money they're trying to make from those events, and so I hate that. So I don't do that in my practice at all. I don't like that sort of a thing. There are better ways to learn about this stuff than going to those free seminars. They just kind of overprice what they're pitching usually. There's a huge gulf. There's a huge way. This conversation can go any way you want. So I'm going to give us some basics right off the top, and then I don't have anything else prepared, which sounds scary, but that's because I have a feeling that you guys don't want to talk about guardianships for minor children today. You probably want to talk about what happens if I have to go to a nursing home. This conversation can branch into 1,000 different directions, and I'm happy to go wherever you guys want. But I want to get some terms out. I don't really want to use the whiteboard because I can't write very well, but I'm happy to put terms up on the board if you need them. So, the first word that I want to define, and I want you guys to know the definition of, is probate. What is probate? It's a really scary word that everybody that does estate planning or retirement tries to, they really want to amp that up. Like, oh, you don't want to go to probate. And what is it? Why is that word used? Why isn't it an anxiety trigger? Probate means stuff without an owner. That's what the word probate means. So if I'm driving down the street and I see a couch on the side of the road, that's technically probate property. If you want to sound like a jerk to your wife when you say, hey, look at that, and that's probate property. She doesn't care. She doesn't. So as you drive down the road and you see that couch, now technically, legally, if something's discarded, it's up for grabs. It doesn't have an owner, it's up for grabs, okay? But if two people run and try to grab that couch at the same time, because let's pretend like two people want to grab a couch on the side of the road, so they run and they grab it at the same moment, who decides who the new owner of that property is? The probate judge. So the probate judge in Utah he has one job. And his name is Judge Howell, and he's a really relaxed, chill guy. But his job is finding new owners for things that don't have owners. That's it. So if you are in probate court, you are fighting over ownership. You're arguing about a property dispute. You are adopting a child. Or maybe your kids are getting a guardianship over you because you're trying to send all your money to a Nigerian prince or something like that. Like that's what's going on. It's an ownership court. So how do you interact with the probate court? Well, the normal way, you can send petitions to the judge. You can say, Judge, this is going on. You need to help me because I'm alive. But you can also interact with the probate court if you're dead. And you can do that with a very specialized letter to the judge. The only person who can read this letter is the judge. So I cannot emphasize that enough. And that letter is called a last will and testament. So anytime you want to tell the judge anything, you can do it. You can write him a will. Nobody else can do anything with a will except the probate judge. So a lot of people will come to my office with wills and they'll say, read my will and have everything divided. That's not how it works. When you have a will, you are taking that will to the judge, who then gives the order. In the will, you usually do three things. You nominate your personal representative or your executor. That's the person that's in charge of going to the judge. Then you tell the judge who the new owners are going to be of your property. And the last thing that you do is you nominate a guardian for minor children or disabled children, if you have disabled adult children. That's it. Every will does just that. There's nothing else that a will does. And so I get a little bit in my mouth when I go in and someone comes into my office and tells me that they spent thousands of dollars with a lawyer preparing a will. Wills take about 6 minutes to write for me. And I don't write them. My secretary writes them. They're really fast. Wills should not take very long. They are not complicated legal documents because they are only doing those three things. They are nominating a guardian, they are nominating a personal representative, and they are telling the judge where to send your stuff. Okay? Now, wills can get more complicated if they start getting into managing things, but that's not actually a will anymore, that's a trust. When the court needs to manage something, they will order a trust set up. A trust is a management agreement. It says, I own stuff, or in the case of a judge orders it, the judge says, this dead person owns stuff, and now we are putting a manager in charge of it. Anytime anything in the law is managed, it is managed in the terms of, under the terms of a trust. And there's a lot of different types of trust. If you set up your trust before you die, then you get to decide all the rules. If the court sets up a trust, it's because there's a minor children, people are fighting, and that would be, when the court does it, it's called an administrative trust. When you do it, it's a living trust or a revocable or irrevocable trust, depending on what you're trying to make it do. Yeah, go ahead.
Am I okay to jump in?
Yeah, go for it.
Can a will be written on a piece of toilet paper and be valid, or does it have to
Yeah, but don't write it on toilet paper.
be? Okay.
I have done a will that was written on a paper plate. So it was like this, like I was driving a little toddler's car, you know. So what are the rules to make a valid will? You have to have what's called testamentary capacity. That is a really low bar, actually. You just have to know what your stuff is and who you want it to go, where you want it to go. You don't actually have to want it to go anywhere smart. But if you think about it, some of you have timeshares, so that capacity didn't have to be very high before you even started. So, no offense to the ones that I'm not trying to sell today. So, but people have paid me a lot of money to get out of timeshares. But I don't do that, so don't ask me. So then the next thing is, so what makes a valid will? Okay, you got to have, if you're going to have it typed, this is the big difference. You got to have two witnesses witness that will. And if it needs to be signed, it needs to be dated, it needs to be identifying that it's your will. But here's the secret. If you just write it in your own handwriting, the rules go down a lot. So technically, it's called a holographic will, but if it's in your own handwriting, not somebody else's, the court's going to bend over backwards to try to make that will valid, and it doesn't actually have to be witnessed. Please don't do that. Go on LegalZoom first and pay the $50 to have a professional will identify your executor, your personal representative, and your guardian. Do not pay a lawyer thousands of dollars to come up with a will. I don't think that is a useful thing to do. Now, sometimes it is worth paying a lawyer thousands of dollars, but that is not for creating a will that just says this is where my stuff goes. What happens if you don't have a will? Okay, if you do not have a will, the court applies the defaults. Everybody has these baked in. They're called the rules of intestacy, because you have a will, which is your testament. So if you don't have a will, you died intestate. You died with no will. And the court is going to apply the defaults. They're going to say, okay, first, if you were married with all of your kids together, meaning no extras, even the ones your wife don't know about, they all have to be in the same family. If that is the case, and then we'll say, and let's just, for the way this is supposed to work, the way God plans this, is the husband, you're supposed to die first. That's how it's designed. And then for the wife, you're supposed to hang out and get Alzheimer's. That's how God planned it. It's not me. I'm not telling you this for the first time. You know it. You can look around your neighborhood. And you're like, yeah, all right. That's why there's like 1,000 casseroles at the widower's house, So the idea is, and you don't have to get Alzheimer's. You can go on the anti-Alzheimer's diet. You just, every time you go to Costco, you eat one of those hot dogs. You do that, you're not going to die of Alzheimer's. You're going to die of the same thing that's going to kill your husband and me and all the rest of us. You're going to have a massive heart attack in your yard. So, intestacy. So when you have intestacy, the judge is going to say, okay, you have all your kids together, everything goes to the surviving spouse, and they are automatically the person that's going to serve as the personal representative. So if you're a kind of a boring couple, a will probably isn't going to make that much of a difference right off the top, right? Because the same thing is going to happen whether you have one or you don't, unless you have minor kids, in which case the will nominates a guardian. So if you have kids from prior marriages, wills become way more important. But remember, wills only cover things that don't have owners. So if you die and you're joint on everything, well, guess what? Everything's going to go to the surviving spouse, right? If you die and you are joint and you have kids on your bank accounts, they're going to go to the kids. By the way, I don't recommend doing that. I think it's a terrible idea, but that's how it works. So if you have your kids on the title to your home, technically, it's not a probate issue. You died, it's their house. The problem is with that specific strategy, I'm going to add my kids to the title of my house. It's their house before you die too. It's their house the moment you give it to them. And then when they go to declare bankruptcy, you lose your house because it's their asset. And then the other problem is after you die, they owe a lot of tax because you get a huge benefit in leaving your kids your stuff. You actually want to die owning your stuff. You don't want to give your stuff away before you die. I'm not talking about your cool stuff like your heirlooms. I'm talking about your money in your house. You want to die and leave that to your kids in some form or fashion because of the tax benefits. They owe zero tax on that up to $15 million. And none of you have $15 million. I can tell because nobody landed in a helicopter, and got out. And they wouldn't be coming to the stake emergency preparedness. They'd make me get in a helicopter and fly to them. So, yeah. So intestacy, let's say, going back, let's say, okay, I've died. I had a kid from a prior marriage, and now I've died. Okay? Well, that kid from the prior marriage gets half of my estate. And my wife, my now wife, gets the other half. So if you don't write that down somewhere, that is like run home. If you have that situation, you don't have a will, get out the paper plate and write, I leave everything to my wife, and sign and date it. Because I have seen some disastrous situations, and I have had some really tough conversations with people who are now losing their home because or worse, because their husband died, had a kid from a prior marriage 20 years ago, haven't talked to the kid, don't even know him anymore. Not talking about whether or not he was a good dad or not. I'm just talking about what happens to a surviving spouse now. Now that kid gets half the house, right? And the other problem is if in that situation specifically, if that kid, if they didn't have if they were, let's say they were joint on the house, but they weren't joint on other assets like his investments. Well, the state says, because we're dividing it 50-50 with the wife and this kid from a prior marriage, we're going to now say, okay, whatever you were joint on is going to offset against the wife's share, and the rest of it's going to go to the kid from the prior marriage. So he might get all of the investments. It can be a really very damaging situation to families. So it's usually not the most common thing, but I deal with it every week. I mean, without a doubt, it's going to come up. And it's super easy to avoid. So we've talked a little bit about death. So trust, when you do a trust, what you're doing, go ahead.
Yeah, I just want to ask, should you do a will and a trust or just the trust?
Well, I'll tell you. So I make my money doing trust. That's the only thing I do. So I'm a big believer in trust because otherwise I don't have Christmas. So I love trust, but it's not just for the money, because if I could, I would sell something cheaper. I would sell something easier to sell, like washing machines. But I really like trust. So a trust says I own stuff. I'm putting a manager in charge of it. And the way that works is the judge sees the trust. Judge is still in charge of it. It's a probate document. It's built under the probate code. But we just don't have to take it to court because everything has an owner. And then if the trust is written well, the rules specify exactly how things go. And I actually, when I write them, don't care a whole lot about the death part. Like the death part gets worked out. Like you might come in and say, I have 5 kids, they're all doing great. And I'll put rules in the trust, even if they're doing great. Because you just never know what's going to happen to people. And there's some specific things that you want to see in a trust, rule-wise for your kids. Even if you have 5 kids that are all making more money than you and all are having a great life. But the part that I care about the most is not your death. It's your incapacity. So you are going to die, correct. But before that, you're going to go through a period of incapacity. That might last a week, and that might last for years. You don't know. I hope it's really quick for me. I hope that I just keel over real fast because the incapacity part is rough. But a lot of the conflict from your family is going to happen when the kids are dealing with someone who's incapacitated. When your spouse is not functioning at 100%, you can do pretty good until they're about 30%. And once they're just like, this person is just the worst, like they're just acting like a little toddler again, family dynamics can shift very quickly. And now you're dealing with home care. You're dealing with people coming in and invading your space. Your kids are starting to tell you how to live your life. And so a good trust is trying to do 2 things really well. Protect your independence so that you don't have your kids coming in and telling you what to do before it's time, and then giving the right people the authority and the rules. Because remember, a trust is a management contract. That means if the trust is that means that everyone who's writing one can come up with their own rules. And that's where I think a lawyer is useful, because he's actually doing some thinking. Go ahead.
Okay, so just say that once more. Protect our independence.
Yeah, your
And the
independence.
second thing was,
And the second thing, I probably haven't even said it yet, is is protect you from yourself. So you got to protect your independence, and then you need to prevent conflict. So there's three things. I just forgot one of them. Protect your independence. That's one. That's the biggest one. The next one is and I just made these up. No, hang on a sec.
Said give the right people authority.
Yeah, I will get there. So preserving your independence is one, preventing conflict, and then identifying the right people. Because if you identify the right people, they will make decisions that are in line with your goals and wishes, and then you give them guidance. And I like, when I do, every lawyer does this differently. When I do them, I like two people. If I'm doing family members, professionals are great if you have a lot of money, but most people don't have a lot of money. And so I like, especially after they pay me, to write their trust. So I like two people to do things because they argue. And I want that. I want the kids to have to bang their heads together. I had one where mom had Alzheimer's and two daughters came in. And I'd written mom's trust. And the two daughters came in and they said, Mom, one of the daughters, I have to remind you, they're coming to a lawyer's office for this. And that's where I kind of wished I was wearing a suit, because it's just so ridiculous. They're arguing, and one daughter has said she'd read that the color pink helped with Alzheimer's or something. So she wanted to paint the interior of mom's house a very bright pink because mom had Alzheimer's. And the other daughter was like, no, we're not going to do that. And I was sitting there going, oh, I'm so glad we put two people in charge of this because now they're arguing about it with me. And the way that I design my trusts is I typically have a mediation. So I build my law firm in there as what's called a trust protector, so they can mediate disputes between trustees. And all I had to do was open my trust, turn to the right page, and say, look, kids, the trust says that you two have to be in agreement. If you're not in agreement on the color of the paint, you can both go paint the house. You can both sign the check. You just can't do anything that the other one disagrees with. So I guess mom's house is not being painted pink. Now, what do you do if that trustee had gone and painted the house pink? Well, now, because the people you put in charge are fiduciaries, that means they have to follow the rules of the trust. They're going to have to, it's coming out of her own pocket to paint that house back. The other thing, that's a really silly example. It can get really crazy. Everybody here is an adult, so I'll tell an adult-themed story. Yeah, no one brought their kids or their little children. So I had a lady, this is a true story. I have to remind myself sometimes that these are true stories. So I had, again, this was not a trust that I wrote. Someone just brought me a trust. Because remember, we're not in court anymore. So if you write a trust, you have created a universe that people are supposed to operate in outside of court. Court is very rigid. It has its rules. Judge Howell's there. If we're out of court, it's whatever you guys came up with in your trust document. And those, the sky is the limit on whether those are well-written or not well-written. And I would say a bad trust is much worse than no trust. So this was not a bad trust. It just was a poorly designed trust. And so in that case, mom had Alzheimer's. She wrote her trust when she was diagnosed, definitely had capacity, but as the years had progressed, it had gotten worse. She had a daughter who lived in her house with her, paid all her bills, from her mom's money. And so you have this situation where it's an intense need. Daughter didn't have a place to live. Mom needed someone to take care of her. This seemed like the perfect fit. And then her brother and sister were the trustees. Sister got into the habit of using mom's money, and mom got in the habit of saying yes a lot. But eventually the Alzheimer's got so bad that mom couldn't say yes anymore. So now we're dealing with theft. And we didn't even know we're dealing with that because that is a slow titration. It's a little bit by little bit. And a flaxen cord. And by the time the sister is doing it, she's used to spending mom's money. And now the justification becomes, well, if mom had capacity, she would allow this, right? And it ended with sister flying to California to get a breast enhancement with mom's money. She spent $20,000. So I guess $10,000 a pop. And then came in. Well, I think they come in pairs. I wouldn't just. So, but she came into the office, or her brother came in and said, again, handed me this trust. And I was a younger lawyer, and I just kind of looked at it and went, oh my gosh. She said, what? Well, in that case, luckily, there was the lawyer had baked in some mediation provisions. So I was able to tell the daughter, look, if you put that $10,000 or that $20,000 back in the bank, I won't call the police and I won't send you to jail, which is what I figured her mom would want. And because the trust allowed for the appointment of a mediator, and because mom had brought me in as that mediator when she had capacity, I was able to work that out with the kids privately. But if that trust had been written differently, I would have had to call the police. And I would have had to have her arrested, and we would have had to go through the whole criminal proceeding. I had another case where I caught a kid. He was appointed sole trustee, and he was just taking mom's money for years and shipping it off to Guatemala to build a vacation home. So the right people are important. And if you say to me, well, my kids are great, and they're not going to do this sort of thing, you have no idea what your kids are going to go through in life. And so my job as the lawyer is to assume that your kids are terrible. And I'm a cynical guy, so that's super easy for me. So no, but I mean, that's the idea. Is my job is to make sure that we are picking the right people. The document itself is not as important as the family behind it. I often say that if everyone was doing great and all the families were focused and everybody, was unified, I would have no job. But luckily, everyone's families are messy, so I do. Even like the nicest, happiest family is going to disagree about what nursing home mom should go to, how home care should be coordinated, whether or not it's time to pull the plug. All of these things cause conflict, and a well-done estate plan is not addressing the death part. It's not a well-done estate plan if it only does the dead part. And I hate to say it, but a lot of lawyers, like people you go in and pay money to, do a phenomenal job of doing the easy part, which is the dead part. They do not do a great job of planning incapacity. It's a real blind spot in estate plan. So when you go in to do this, or when you're planning your own, you got to deal with incapacity. It's got to be dealt with really very well. If you don't do that, there's some blind spot. Now, there are some really easy things you can do to deal with incapacity that are not expensive. Powers of attorney. Okay, you've heard these terms before. What is a power of attorney? A power of attorney is a permission slip that says, I am giving this person permission to do something on my behalf. Okay? What happens if you don't have a power of attorney, but you act crazy? Well, then the court is going to get involved, the probate court. So having a power of attorney is almost just as important in avoiding probate or making the probate process work as a will. So power of attorney says, I own stuff. Now I can give power of attorney to you to handle my Blockbuster video account. You're going to have very limited powers of attorney, or you're going to have very broad powers of attorney. Powers of attorney are the number one document that is abused. Because if I give you power of attorney, that means you can now act on my behalf. And in the 50s, they were invented as kind of the poor man's trust. And they make people poorer a lot. So I am really wary of powers of attorney. I do them all the time, thousands of them a year. But I don't just hand them out willy-nilly. And you can go to your bank, you can print them off the internet. It is a good idea to have them. It is also a good idea to know what they are and what they're doing and why you're giving them. There's a financial power of attorney. The free one they give you at the hospital, which is the same form everybody uses in Utah. The living will is the healthcare power of attorney, or the living will, if you want to be. Sounds really confusing. A living will is the pull the plug document. That's the one that says, this is who's in charge of pulling the plug. The healthcare power of attorney says this is who's in charge of making medical decisions. So those are two separate documents that both deal with incapacity. And if you have a trust set up, you always do a will. That question came up. You always do powers of attorney with the trust. But your will, if you have a power of attorney, says, because remember, wills are letters to the judge. If I have a trust, my will is going to say, "Dear Judge, I've died, but I have a trust. So if anything accidentally ends up in court, send it back to my trust. Don't deal with it here." And that's your backup will if you have a trust. Okay, question?
So with the power of attorney, is it something that you can write in that says this person gets power of attorney if this event happens?
Yeah. So when I do them, I almost always write them that way. Springing powers of attorney. And this is the trickiest part, probably, of where I see lawyers trip up a lot, is they say, it says my power of attorney or my will or even my trust takes over if I become incapacitated. And then they do a really crappy job. Oh, shoot. Sorry, I swore. They do a really terrible job of this defining incapacity. So they didn't think that through. So I've seen one where, and the incapacity standards vary widely. I saw one that was like, I'm incapacitated if my neurologist, my psychologist, my general doctor, and one other uninterested doctor, so 4, all agree that I'm incapacitated. Well, that's going to take me 8 months before I can get this person declared nuts, and they're streaking down the street, like it's obvious that they're nuts. Like I had a lady go to Macy's, and she just, this was not Macy's the grocery store, this was Macy's the department store. She stripped down and was just hightailing it nude all the way to R.C. Willey's in the mall, and this is one of my clients. I got this call and I was like, oh, well, she's like 85. And I have learned in my practice that most nudity is bad. Like it's almost always bad. Like it's usually like, oh, it should be contained to very specific circumstances. But anyway, that was a guardianship case because she didn't have powers of attorney. I had only knew this lady because I did her dad's will, or her husband's will, through probate. She had done none of her planning. That was a case where we had to go to court and find a guardian. And that was what I was going to say with powers of attorney. If you don't have powers of attorney, the downside is really bad because you got to go to the court and go through a guardianship and conservatorship hearing where they appoint you a guardian. Okay. I've covered just about all the stuff I want to cover, like just defining basic documents. There are tons of other types of documents that do tons of other types of things. So questions that you may have. Anyone have a question?
Before we get too far,
Yeah.
you said springing.
Springing powers of attorney, yeah.
Can you define that a little more?
Yeah, so a springing power of attorney comes into play when one of those incapacity triggers happen. So when I do it, I usually say 2 doctors need to sign off that you're nuts. And I say 2 because your first doctor usually won't do it unless he knows he's going to be, I say he or she, is going to be backed up by another one. There are specific GPs that do capacity, and what they usually do is show you a picture of a pink elephant and then ask you if you can remember it was a pink elephant like 5 minutes later. And if you can do that, you probably don't have Alzheimer's. So that's how they do it. And I think there's probably a little bit more professionalism involved, but if 2 of them do that, you're nuts, or if you're off your meds. I had one where a young couple, like younger than me, kid went off his meds. He was bipolar, decided he was going to sink his 401k into buying the Batmobile. And so he took off to California to spend their whole family fortune on the Batmobile, from the movie. And it wasn't even like a good Batmobile. It was like 1995's Batman Forever. I was like, yeah, he's nuts. He doesn't want that one. So he starts driving off to California. And what you do is you're kind of like, okay, where do we go from here? His wife had done a trust, luckily. By the time he got to California, we'd had the doctor sign off. He had no access to his bank accounts. His wife iced him out. And that's what you want. You don't want him to go spend money anymore. And a lot of the time, it's husbands and wives doing this to each other first, because one of you is going to get crazy before the other one. That's kind of how it works. Okay, other questions?
Yes, I was wondering, if you have a car, a vehicle, and boats and all that stuff,
Yeah.
should that go into the trust?
Some things should go into the trust. I forgot to say this. I'm not giving you legal advice
Okay.
because I'm not your lawyer. And I actually hope I never am your lawyer. Because I don't love doing this for people in my own neighborhood. Because when it goes south, like I did a prenup for my neighbor once, and I thought that was a good idea. And then for years afterwards, the lady who was who we'd done the prenup with, she had her own lawyer, was like watering her plants, glaring at me across the street because I'd represented the husband. So I don't love doing this for people in my own neighborhood, but to answer your question, yes, your boats I would probably put in the trust, your car I would not.
Okay.
Here's why. In Utah, probate is triggered by, I'm going to get this wrong, 3 or 4 things. I'm not very good at numbers, ironically. So if you have a house or any real property, that triggers probate immediately if there's no owner. If you have more than $100,000 in your estate without an owner, it triggers probate. Or if you have more than 4 vehicles, any vehicle, including trailers, boats, ATVs, it triggers probate. And so because of that, I have gone to probate over 30 cars, all 1984 Oldsmobiles in people's yards, and nothing else. That's a probate trip just to get them to the junkyard, because it's more than 4 vehicles and I got to get a court order on it. And so my rule is usually the toys, yes, go into the trust. The cars don't, because if you hit somebody with your car, I don't want the person who you hit to know you have a trust, because there's a lot of, like, even among lawyers, they assume if you have a trust that you're rich, which is not true. But they still think it is. So the slick-haired guy at Siegfried and Jensen is going to come after you, if you hit him with a trust-owned car. And I don't really believe in that. Okay.
So what about bank accounts?
Bank accounts should go into a trust, and I like that, because if you have like your kid on the bank account, I got to tell you one of my favorite stories from doing this. And I apologize, I do tell boring stories, but I was a new lawyer. I have a little office in Lehigh up from the roller mills. It's just an old house. And I was sitting in my conference room, and 5 brothers brought me a will. Okay. This is not a parable. This is a true story. And they were all sitting around the table, and they handed me this will. And I'd been a lawyer for a few months, saying I'm a probate lawyer. And I read the will, and it said I give everything equally to my kids. And for context of this story, it was a fairly small room, and the boys were fairly large, like way larger than anybody here. Yeah, way larger than anybody here. Like these are like a pod of orcas, like these are big boys. And I was smaller, so I was kind of like, a little mouse. And I was looking at this will, and it said, okay, everything equal. Well, this should be really easy, right? And the guy says, well, yeah, and before Dad died, he made it even easier. He put Brad on the title to the bank account, and he just put all of his money in there. There's $2 million in that bank account. I said, the plot thickens, because now that bank account has an owner. And what does the will cover? Things that don't have owners. So that means I said, Brad, congratulations. This money is now yours, but you are welcome to share the money. And Brad, he's not named Brad. He's not your stake president. So that's not him. So, but this guy, I've just made up a name. So Brad stood up and ran out of the office, waddled out, just boom, pushing things out of the way. And all 4 of his other big brothers ran after him. And I still have the will. They left it and they didn't pay me anything. And the last thing I saw was Brad peeling out in a 1995 Mazda Miata, like the worst Corolla ever. Smallest convertible, biggest man. And the last thing I thought as he peeled out and drove down Main Street in Lehigh, as I watched, I thought, that is the last time that man is going to ride in that car. Like tomorrow, he's riding in something different because he just got $2 million. That's a long answer to a short question. Like, so what do I do? Do I put the kid on the bank account? Way easier. That's where you might want to use that power of attorney. And this is funny because the banks think they're estate planners. And here's a little tidbit. They are not. They are just teenagers that kept working at the bank. I mean, so bankers and I fight a lot because they do stupid things. And one of the stupid things they do is they say, put your kid on the bank account. That is not helpful in an estate planning context. It may be easier. It's easier for them, but what is much better is you can make them a signer on the account so they can access the funds, but not own it. And you want to specify that when you're with the banker and make them do the extra paperwork. Or you can just use a power of attorney that gives the kids access to that checking account. Why just the checking account, not the savings account? Because you don't want to give up your independence. Don't do it. It's yours. You're still alive. You're just old. So, yeah, people think that when old people get old, they are not fun anymore. And that's true. But it is also true that you guys are not, you're still people. Like, I love it when someone dies and their kids come in and say, you wouldn't believe it. Mom's getting remarried. And I was like, well, did you just want her to sit there and watch The Price is Right for the next 20 years? Like, what? Of course they're going to get remarried. They're people. And I don't like trading independence. I think that's a stupid idea. I think you empower people to help when you decide. So if you take anything from that, from my whole thing is you don't have to give things up just because you hit a certain milestone and your knee hurts really bad. You can bring people in to help if it's time. And you decide that. You get to make those decisions. Your kids do not. Okay. Other questions?
So you talked about an executor, power of attorney, and a trustee.
Usually it's the same person.
Okay, the same person.
People, yeah.
So if we were to assign one of our children to do that, I've heard people say, oh, don't do just one.
I like 2. I'm a big fan of 2.
Okay, so 2 over 3?
Never 3.
Never 3. Somebody says that you have to have
Never
somebody,
3. Yeah, that's
you have
all.
to have 2 agree.
Yeah, and lawyers say that too. That is such a terrible idea. And again, I'm not wise. I want to make that clear. I'm a real idiot. I just know about this. It's because I do this thousands of times. So this is the only thing I know about. If I put 3 people on, 2 will outvote 1, and it's the same people every time. And so a conflict arises. The same 2 will always outvote the 1. And usually those 2 people are right. Usually there's 1 weirdo and 2 that have it figured out. And the weirdo is the one I want out. You know, like we could save a lot of time if you just shut up. You know, like no, we're not going to do it. We're not going to wait 10 days before the funeral. We're not doing it. I had one where the kid and they left me a horrible Google review. A terrible one, which for my world is like, oh, now everyone thinks I'm bad. Well, what it said was, this lawyer, you wouldn't believe it, he won't let me leave the animals in mom's house until the house is sold. Well, by the time we got there, the cat had eaten the parrot, the dog was malnourished. I mean, I was like, guys, who do you expect to clean this up? Like, get the animals out of the house, you know? And that was, again, you want 2. The third one is always going to get their feelings hurt. And that is counterproductive to what we're trying to do. That reminds me of another really fun probate story. I did a probate. Lady died in Payson. She lived over behind the movie theater. And the house was just not great. Dog poop everywhere. And she had 5 kids. And one of those kids, this is one of those rare circumstances where you put one person in charge because the other 4 had been in and out of jail. And so by default, she had one that had not gone to prison. And so that was the executor, luckily. Again, I had nothing to do with this. I was just dealing with a dead lady, right? She had died. I'm in the house, and I'm like, how are we going to get this house cleaned up with all these deadbeat kids? And no one was showing up to help clean the house. And I was like, oh my gosh. And so I said, okay, I did not go to law school to clean up dog poop in this house. Like, I did not. So I'm not going to charge the estate to do it. So I said, whoever shows up, I will pay you $30 an hour off the top of the estate to get this dog poop cleaned up and to make the house sellable. And I'll tell you what, I don't think any one of those 4 guys had ever even thought about making $30 in a day, let alone in an hour. And they showed up and cleaned that place. They did great. And then I got a call from the executor that said, hey, Brad, was in the house after we left, and he kept cleaning, but he ruined every door in the house. So you're going to have to you're going to have to reduce his share for all the doors we have to repair. I was like, wow, what happened? Well, after we all left, the SWAT team came and got him, and they blew all the doors off. And I was just like, what? So then I go to county jail, and I say, Brad, look, man, like there are 3 doors they had to blow off to go get you. So, like, I guess, I'm going to reduce your share by $1,000. Is that fair? He's like, yeah, but you got to credit me because while I was hiding from the SWAT team, I was also cleaning. So I get my $30 an hour. I was like, I don't know what you were doing, like the baseboards under the window, or something, but yeah. So that was another weird one that I dealt with. Okay, go ahead. In the back.
Okay, you talked about a will and a trust.
Yeah.
And a will that defines how things are going to be divided.
That's it, yeah.
But you talk more about a trust holding property or holding things. And is that so there is an owner? Could you maybe clarify?
So why does a trust hold stuff? So, like, let's say I'm writing a basic trust. And I don't really believe in basic anything. When I write something, personally, I like to write things so they're going to cover it. So let's say you came in and let's say you have 5 kids and they're all doing great. I could say in your will, I leave everything to my 5 kids, or I can say that in your trust, I leave everything to my 5 kids. But because we're using a trust, I can also say these kids get this money so long as they're at least 25 and they're not incarcerated, bankrupt, disabled, dependent on the trust for support, or addicted. And I can spell out all of that. And if they are these things, then the trustees get to hold their share and manage it for longer. And I might write that even when I know there's no addiction. Just in case one of them dies and now a share is going to a grandkid who has a heroin addiction. I deal with a lot. I say my practice is run on heroin and greed and entitlement. Those are the 3 things that keep me in business. So I wrote a check once. The relationship with the trustee was so bad. This grandkid was getting a check for $86,014. And he could not see his aunt, who was in charge of it, because there was so much conflict. So they dropped the check off at my office, and I handed it to the kid. And 16 minutes after he left my office, I got a call from Check City, and they charged him $14,000 to cash that check. And so sometimes people need money managed, even small amounts like that. Had the aunt been in charge of that, she could have ensured that $86,000 did not go into a rager that weekend. It went into something like paying for his apartment, school, rehab. There's a lot of things where, and this conversation can get really specific really fast, but like if you give a disabled person, if you give a kid who's on disability benefits money, the government's going to cancel their benefits. They just cancel. If you get more than $2,000 and you're a disabled adult, you have no more Medicaid. You have no more monthly checks. If you leave it in a trust, and if that trust is set up correctly, it's not their money. It's the trust money. So I regularly have people who are very, very not happy they are getting inheritances because they're in the middle of a divorce, they're in the middle of a bankruptcy, they're mad because, and they want their money managed longer. The trust manages the money. So that is a big advantage of the trust, is it actually can hold things. I can put rules on what happens if you have a kid that goes to prison or a grandkid. And you don't need to go overboard, but they do need to be very specific. And I do find that things that trusts can get, people make very bad decisions if they don't write those rules very clearly. Yeah. Oh, sorry. One in the back.
So if you have investments with beneficiaries,
Yeah.
do you encourage using the beneficiaries to disperse the money or to put everything back into the...
That's going to be a very client-specific discussion. Sometimes every dollar that they have goes through the trust because their beneficiaries are terrible. And sometimes they don't. It depends on how much money. But when I write my trusts, I write them in a way that if the client decided to move everything into the trust, it would not be a big deal. It would be handled correctly. Okay, go ahead.
About the will. So if you do write a hand will, or you make one for kids or whatever,
Which don't do that. Go on LegalZoom. Don't do the handwritten will. I know that he's not asking that.
but the question,
go ahead.
The question is, where should this will reside so that it's accessible to the people who need to make that decision?
That's a great question.
Afterwards.
This is a great question because if you stick it in the safety deposit box, I have to go to the probate court to get the safety deposit box open because it doesn't have an owner. And so I have I have done some really crazy ones. So best thing to do, because wills get edited a lot and stolen, is you want to tell people where the will is, have it in a home safe, and make it clear that your kids know where it's at and what it says. I like things to be transparent. Now, of course, when I do documents for clients, I keep copies so that if they don't, if they lose them, but then lawyers go out of business or they win the lottery or something, I'm hoping, and then they quit. And so you want to make sure that you have backups, but copies can be dangerous too. Because if you have lots of copies and you hand them out to all your kids, number one, you're asking for input from people who have zero reference for why. So I don't like getting opinions from kids about their parents' wills. It's none of their business and they're not prepared to even have that. And if you give copies and then you change it later, now I've got copies that say different things. Another one is don't write on your documents once they've been signed, because anything you write can be an amendment. And so crossing things out, changing last names. I've had them where it's like, I hate this daughter, cross her name out, and then, the fight and the whole page in the margin is just their relationship, summarized, disinherited, not disinherited, disinherited, not disinherited. That's not the place to do that. Your legal documents, you don't write on them. Okay, go ahead.
In keeping with the Provident Living theme, do you advocate having a legal notebook that has copies of this stuff and marriage licenses and stuff so you can grab it and go?
Way easier. And also a good summary of where your insurance is. Like a good packet. Write it all out so that people know where your stuff is, because I can't tell you how many times money has been left on the table because people didn't know where it was. Especially if you're one of those prepper people that have 8 bank accounts across, 30 different institutions. I don't know how that math works, and you have to go to all these different banks. It's much easier if things are organized simply. One bank for your joint expenses, another bank so that you can spend money that your wife doesn't know about. And that's it. Okay, go ahead.
So just a really quick clarifying question. You did cover this a little bit, but when we're talking about small children, and so if there are small children involved, you want to make sure that they have someone caring for them if you were to die suddenly.
And I don't like them to be
best way to make that happen right?
That's a great question. Again, not relevant to the people that are sitting here. because you all, but you have grandkids, and then some of you have to raise them. So I get it.
But there are also people that have questions that aren't able to attend.
No, I'm
because of
not.
little
Yeah, I'm not
kids.
patronizing. I'm not trying to patronize. I'm just making a dumb joke. Yes, young families, which ironically, a lot of the people coming in to talk to me are young families. Here's the thing. You don't necessarily want the same person being the guardian as you want being the person in charge of the money. So when I do like a trust for young families, typically I'll say all the money is held in one place. And again, we can do this because it's a management agreement. In court, judge is just going to say, okay, young kids, we're dividing this up when they turn 18. The court's going to hold it in this kind of lockbox until that time. It's not very efficient. It's not very helpful to the little kids. So I like a different structure. Have all of your money in one place. I would call that the common trust, and I would hold it there until the youngest turns 18, then divide it up. And the trust can do that. It can program this basically. And then once the youngest turns 18, you've divided up the money. They all get their money, and you might put rules if they're all good kids at 20 or 30, depending on how big the estate is, so long as they're not incarcerated, bankrupt, insolvent, disabled, all that stuff. And what you're trying to do with young kids is you're trying to recreate how it would be if you were still alive, right? So I might say there, the older ones can borrow money from that pot to go on a mission, to make a down payment on a home, but not to invest in Mary Kay. And the trustee, you're there to be guardrails, because people in their 20s are really, really stupid. And they're supposed to be. They're not supposed to have a lot of money. It'd be really bad if all 20-year-olds had lots of money, right? That would be a big, big misallocation of resources, because they don't do things good with money because they think they're going to live a long time. So you want to try to use those trusts to guide their decision-making if you kick the bucket. There was another question that I left on the table. Okay, go ahead.
Could you go back to the homes? Should they or should they not be in the trust?
Homes have to be in the trust. That's the most important thing. In fact, if you don't have a home or real estate, trusts become less useful because they really are best at managing property like that. I find them most useful for houses. And any house will trigger any house, especially now, like we all woke up and became millionaires because the houses doubled in value. Like before 2020, we were all poor and we really didn't need any of this. And then we're all now very rich. We just don't know it because we're still in the same house. That shift, and where I see a lot of the conflict is now your kids are 40, but they can't afford a house because they weren't old enough right when before the pandemic, and now they're being priced out. That's creating a lot of family conflict right now. The property that was cheap for us, if we were lucky enough to buy before the pandemic, is now prohibitive. And when families lose their homes, the trust is really where it's going to iron out that dispute. Is the house going to get sold? Do you have someone who gets to live in the house for a few years after you die? All of that can be handled within the universe of a trust, but the rules have to be pretty clear. You don't want to have that. You don't want to do a half-baked job on that. Okay. Yeah.
So when you make a trust, you can set it up for grandchildren, for missions.
You can do whatever you want in that trust. You can set up for missions
or education.
Yeah, I write trusts where people are like, I had one guy, he had $10 million. That $10 million went into a fund, and I did not suggest this, but I also didn't say no. So I guess I am complicit. And it just said, I give my $10 million to any of my descendants who wish to use it for tuition to go to welding school. Okay? That was a very disappointed group of kids. So like they were like, okay, what the? And then there was a lot of expletives. Like I learned some words. Like, it's bad when they pair the swear word with the adjectives. It's kind of like Yosemite Sam, That's when they're really mad in Utah, I've learned. And there was some of that. But on the flip side, they are very good at welding, So So, like, if I need like my fence fixed, I know I can call that family. And he was just a guy who believed that there needed to be like a hard skill, and maybe he was prescient because AI is supposed to fire me and everybody else soon. He was like, okay, I want my kids to have like hard skills. Yeah. Yeah.
I'm wondering about how you plan for incapacity. Like, what would that look like in a trust?
This is such a good question. This is my favorite question. So incapacity is loaded, okay? So when I write a trust, so first off, you have a plan that you've talked about with your kids. And this may involve a social worker, a hospice social worker if you're late in the game. You have to know before you start planning for incapacity what all the rules are around nursing homes and how they work and who's going to pay for them and how they're going to get paid for. That is a whole nother discussion that we could have for hours because I do know all those rules as a hobby. I don't make a lot of money off those rules because it turns out that if you're going to a nursing home, you're usually already poor. But you have to know the rules before it happens, and you have to have a conversation because one of the things I find is that kids will go to you'll fall and break your hip. So now I broke my hip, and I can't tell you how many times I have experienced this where they call me and they say, okay, mom's in the nursing home. She fell and broke her hip. We sold the house. Now what do we do? I'm like, well, look, you moron, you sold the house. What were you thinking? Now you have a pot of money you have to spend to pay for nursing care. And the nursing homes are a business. So when you fall and break your hip, they are there ready to pitch you on this land-based cruise that they're talking about, where they're going to take care of you and they show you the shining chandeliers and they walk you through them. That is not necessarily what moms need. So a good incapacity plan is we're slowing things down. We're saying, here's where we're having discussion points. So usually in my trusts, I'm writing nursing homes are a last resort first. Assisted living is a last resort, unless I can make the decision myself. Home care first. I want you to try home care first. I want you to speak to a professional who knows Medicaid and knows nursing care. And this is if I just fall and you can't find me. Well, you can't find me, of course you found. I can't, I've fallen and I can't get up, but then you can't talk afterwards. This is, you're incapacitated. This is the plan for the kids. Slow it down. Don't overreact. This is not a stop, drop, and roll situation. This is a let's get our information first before we make really, really serious decisions.
Okay.
Yeah, so that would be, that's why I like two people. Because one person makes those decisions. You want this to be, and the more rules you have worked out, the better that incapacity discussion can go. I have one other one over here. Did you have a question?
So how long is a power of attorney or executor for lifetime? Because
Yeah.
I had my parents have been gone for one almost 10 years, 8 years or so, and I had a nephew that passed away.
Yeah.
And we were trying to find a place to bury him. And I says, I really think mom and dad have another cemetery plot. And the executor says, no, I don't think so. But I went to the city and I found out that they did have one more plot, and that it could be given to that child if there was an executor.
Well, here's the thing, and again, not legal advice, but powers of attorney are permission slips, right? Remember I said that. I know I said that. That means if I write a power of attorney, I'm giving you permission. I can't give you permission if I'm dead. So power of attorneys terminate the moment you're dead. Then the will takes over. The trust straddles both. That's why I like trusts. The trust combines dead and alive still. Another question.
Isn't one of the big advantages of a trust the step up in basis on your assets without going through the hassles of probate?
So so step up in basis, what does this mean? We're going to talk tax for a sec. The answer to that is partially, but you've also been overpitched. So like lawyers really like to say, avoid probate, avoid taxes. They're trying to sell you a product, right? Okay. And, oh, by the way, don't do this with a non-lawyer. That's illegal for them. Not for you, but for them. So the guy that says, I used to work at a law firm and I can write your trust, does not know what he's doing. I mean, if he's saying that he does, he doesn't. And he doesn't have malpractice insurance, which means if he messes it up, and he will, it's going to go badly because your kids will not be able to sue him and get paid. So that is an aside I wanted to bring up before. Not to toot my own horn or anything, but if you wouldn't want a non-dentist taking your tooth out, don't go to a non-lawyer to write a will. Back to that question on basis, and I know people want to get out of here, but like, let's say I have a house and I buy that house, and I bought it because I live in Payson. Let's say that 15 years ago I bought my house for $10, and now that house is worth $500,000, which is kind of seems what happened. And then now I want to sell that house, right? Well, the government says off the top, okay, we're so excited that you're selling your house, but we notice you're rich now, so you have to owe us some money on the gain. I bought the house for, let's say, $100. I'm selling it for $500. That's $400 of gain that the government is going to tax at 20%. Now, there's some exemptions if it's your personal residence, because they know that you have to live somewhere else after you sell your house, so they're going to give you each $250,000 of exemption. When you die, if you give that house, let's say that my parents gave me a house. Whatever they paid for that house, if they were alive when they made the gift, is now my basis. So if my parents bought a house for $100 and they gift me that home, I am now a $100 into that house, the same as they were. If it's a lifetime gift, the basis transfers. If I die and leave someone my house, then this is the real nice part. You get a step up in basis. That means no capital gains. It resets to the value of the asset at the date of death. This is why you do not add your kids to the title of your house. As a practical matter, it's a terrible idea just because you don't want to add kids to the title of your house because now it's their house. And I have gotten calls from women, old ladies, multiple times in KOA campgrounds or something else that just said, I added my kid to the title of my house, and now they evicted me, and now I'm at the campground. What do I do? That is a real conversation I've had multiple times. So don't do it. But also, if you want to try to convince a really sure of himself moron kid that it's a bad idea and he needs to stop pestering his parents to put him on the title, but that's another conversation I have a lot. You just say, well, look, it's for taxes. They need to leave it to you when they die because you're going to get that step up in basis. But here's the secret, back to your question. The trust doesn't do that. That's just the law for everyone. So if you die, then your kids are going to get the step up in basis. You don't have to do a thing about it. Just don't add them to the title. The only thing the trust does is it organizes your stuff to avoid probate, which was the answer, which is what you said. So it does avoid probate, but it does not affect the taxes. So trust will avoid probate, and it organizes your stuff to reduce conflict during incapacity. That's what a living trust is going to do.
What if you sell the house and the cash? What happens? Do you have so many years that...
After you die or before you die?
Before you die.
Okay, if you sell the house before you die, this is not an estate planning question. This is more of a tax question. So you could drag an accountant in here and pester him with this stuff. They are way less fun to talk to, though, because I talk to a lot of them. They're pretty boring. So an accountant they're going to tell you, you have to have lived in your home for 2 years, in which case you get a $250,000 exemption per person, so $500 per couple, on the gain of the home, and that is filed on your taxes that year. The rest of it is tax-free. They don't care. So if you sell your house, you can exclude $500,000 and put it in the bank. You don't have to immediately go buy another property like it was a business property or something. Yeah.
So we want to say thank you for coming out and taking time to talk to us. We had a lot of really good questions. We've gone 15 minutes over, so I'm glad there was a lot of questions. But we do need to put a stop so that you guys can get back to your day and that our guest can also get back to what he needs to do today. But thank you everyone for being here and for participating and asking questions. I didn't understand what you said.
Have all the resources.
Yes. So Brother Morgan offered to give us access to some resources. So I'm going to be sending out an email to everyone who is signed up for our newsletter. So if you are not signed up, there's a QR code right here that you can scan and sign up to that newsletter. I will be sending out a link to this video on YouTube as well as some of those resources that he's going to make available to us so we can go and kind of look at some things. I don't know exactly what resources
I think I'm just going to put a link to just like a generic, I'm just going to give like a link to the generic powers of attorney. I think everyone should have a living will. I don't know about a financial power of attorney, but you should definitely fill out the healthcare power of attorney because that one nominates a guardian and it also puts somebody in charge of your healthcare. And that one is probably one of the most hot button issues. So I'm going to put a link to that.
Okay.
So you can get that.
So I'm going to be sending that out to everyone. So make sure that you're signed up for the newsletter and then I can get that to you. And just one last question so that we can all kind of be informed in this. What kind of a price should we be looking for in terms of our wills and trusts and that, so that if they are going to find somebody, they don't get ripped off?
Yeah, I do want to cover that. When I do this, when I'm pitching myself, I like to be so transparent. It's not funny because I find that there are a lot of people that overprice this. What I care more about is when they underperform for the price. So everything we talked about today, if the lawyer is getting lost in the weeds on an incapacity discussion, he's probably not your guy, right? Because that's the most important part for me. So that would be the first thing. How much should this cost? In Utah County, the average price right now of a lawyer-prepared trust, and it's gone up since I started, is somewhere between $2,000 and $3,000. But there's a big gulf in what that $2,000 or $3,000 is buying you. And this is why I told you, if you get an invitation to go to a steakhouse, you're going to be paying $3,000 for a $1,000 trust because they got to pay for the steak, and it's like a mass produced. So between 2 and 3 is normal, but I have seen good lawyers do good work for less. Sometimes you might see it but usually you get what you pay for in this business. But that is for a well-done trust. If you are doing a will, lawyers love, and I don't know where it's coming from. I have never charged more than $100 for a will in my life because they take no time to set up. A will is so basic. It can be done yourself on LegalZoom. My will is just as good as a LegalZoom will. A will is a will is a will is a will. But if you're doing the incapacity side where we're planning, to have a plan for the kids, that's almost always a trust discussion if there's a house involved. And that I think you should plan somewhere between 2 and 3. If you're getting beyond that, I believe the lawyer is overcharging. And there are many lawyers who do great work, and then I'll refer to them because I don't take every case. So sometimes, like if there's a conflict of interest or it's, a family member, I don't want to deal with it, I'll send them to another lawyer. And then I'll hear the price tag, 5, 6, 7. I heard a lady in Orem charging $8,000 for this. This is not, no, stop. It's not taking that long. This can be done very, very well and very, very efficiently between 2 and 3 after you've done your staff. So I would get quotes. Even I'll tell people that's just in my office, we'll be talking and they just seem unsure about me for obvious reasons and for the whole process. And I will say, just come back in a month and go talk to 2 other lawyers. Why not? In fact, even today, just go talk before you do this, and you don't have to do it. You're not going to die tomorrow, probably. Like in your lifetime, 99% of your life, you're alive. It's like Like on any given day when you wake up, like just on the law of averages, again, I'm not super great at math, but there's like a 99% chance this is not the day you're dying. Like out of your whole life, you're only going to die once, So keeping that in mind, I don't think you have to do this. You don't have to run home and do this immediately. This is information you have. You're going to bake it for a minute, and hopefully you wrote it down if you're starting to get dementia, because then you can come back and review it. But you want to talk it through with as many different people as you can. I'm just this is the first time you've heard this. Go bang it around with someone who tells, no, that guy was an idiot. This is what you really should do. And then you do what you feel is comfortable for your family. That was another long answer to a short question.
All right, but thank you very much for all of these long answers because they were very helpful. And so definitely take some of this advice, and we will see you next time. Third Saturday of the month, 9 o'clock in the morning, same place. And we're going to be covering a lot of emergency kits and how to put those together. So please come to that. Thank you.